Bob? Yeah.
I'm just wondering, in light of some of the comments that Honorable Bowman had said, do you plan on taking this to Ministry of Finance and helping to educate CRA or get them to educate CRA and their advisors?
No, I think that in general terms, the way that we tend to try to resolve matters is through the court. And that is always a challenge. And there are times where legislation is modified based on court decision. Perhaps, Judge Bowman, you could talk a little bit about the way that legislation sometimes gets affected after a decision from the court.
I'm trying to think of any cases where that has happened. I don't have any doubt that the CRA is, I hope, trying to follow a decision in Northwest Hydraulics. But I'm not aware of any changes in the legislation.
Yeah, I think changes are doubtful. I think CRA guidance documents are, they do provide at times a balanced view of documentation. They do describe routine engineering in the way that we've been talking about today. The practice of adjudicating claims may be different than what guidance documents say. So I think if guidance documents were followed and that things were considered in the light of, say, legitimate uncertainties being, say, a system uncertainty or perhaps a path or a route that, is being considered as a best option. Those things aren't always the case, and it isn't always that CRA officials are familiar with their own guidance documents. So I think that the best way to make change is through forums like today. It's through influencing CRA 1% at a time through the review process, and it's also achieved in part by what we can do in the courts. And I think that's where we look to make our change.
Okay, that's a good comment. I'm just thinking that when you read the guidance documents, that's one thing. When you experience an audit by a technology advisor, that's sometimes a different thing. And you made some salient points about perhaps educating the advisors to case law.
Yeah, there's a reluctance that they have to want to hear about case law. There's a reluctance that they have, sometimes regrettably, to want to hear about their own guidance documents. But if the rules of engagement can't be determined, where is there an equitable result for taxpayers? If the taxpayers are relying upon CRA to be the authority on the subject, they're in a particularly precarious position. And as advocates, I think it's incumbent upon us to ensure that clarity is given. And I believe that one of the ways to do that is to talk about these cases, talk about Chief Justice Bowman's decision, talk about what it means, to have well-known technologies that are being used in non-trivial combinations where there's an adverse reaction, and why that constitutes an uncertainty, why a very small amount of knowledge gained is sufficient to be considered an advancement when you have someone skeptical who's sitting across the table, who refuses to see an advancement, purely because of the fact that it's not something that seems to be profound.
There's another point, too, that should be emphasized. There are two classes of revenue advisors. There are those who will not be influenced regardless of how many cases you give them or interpretation bulletins, and there are those who can see the common sense answer and they don't need any cases to.
I think humility on the part of a reviewer is also important. I mean, it's never our intent to correct, a CRA official per se. There's professional pride. There's, the obvious respect and dignity that we believe that government officials ought to be treated with. And when we discuss the law, they have to be willing to accept at some level that they might not have been right in their first perfunctory decision. And that does take a degree of humility.
Agreed. Well, I'd like to thank Mr. Bowman, and because what I heard is very, very interesting from his point of view.
Thank you.
That's all I have.
Thank you very much.
Thank you, thank you.